Hi, my name is Ayadeji Badaki, and I'm a Maryland barred attorney and an active volunteer assisting low-income Marylanders through several pro bono agencies, including civil justice. I hold a JD from the University of Baltimore School of Law, as well as an LLM from the Georgetown University Law Center, where I was founding member of the Georgetown Securities and Financial Law Forum. I assist clients throughout the state of Maryland with tax, legal, and other similar matters. I'm here to talk to you today about the foreclosure timeline in Maryland. Now, as we're all aware, since the 2008 economic recession, there has been a crisis, a foreclosure crisis facing everyday people like you and me. Maryland, as well as several federal agencies, have come together and passed new laws and new regulations that have improved the foreclosure experience for the most part. This video will describe the new foreclosure timeline and the rules surrounding said timeline as they relate to you, the homeowner. Now, it's important to keep in mind that this video is going to talk about the quickest path to foreclosure. There are several players involved, and there are several types of issues that could delay the timeline. However, for you to get a good understanding with respect to what can be expected, we're just going to take a look at what essentially is the worst case scenario. What is the fastest path to a foreclosure sale happening? The foreclosure timeline starts the day after a homeowner first misses their payment. Now, this can be as soon as the payment is missed, and this is referred to as a default. Now, for the rest of this video, it would help for you to think about this missed payment as day one with respect to the foreclosure timeline. Now, after this default occurs, the homeowner can expect to receive a notice of intent to foreclose. Now, this notice of intent to foreclose will be coming from the servicer. The notice itself is not a court document. It does have legal significance in the sense that once this document is received, other aspects of the timeline can come into play. The document itself has very useful information to the homeowner concerning options they may have for what's referred to as loss mitigation. Loss mitigation is a general term that's used to refer to ways in which the homeowner and the servicer, that is the bank, can work together to see what they can do to avoid a foreclosure. Now, the notice of intent to foreclose under Maryland law has to include information pertaining to your loan. It also has to include information with respect to a homeowner having the opportunity to speak, for example, with housing counselors. It will have phone numbers for such housing counselors all across Maryland, especially within the homeowner's county, etc. So it's an important piece of it's an important document, and it contains a lot of important information. Once that notice of intent to foreclose has been sent, the servicer then can move forward in the timeline and officially put something before the court, asking the court to what they call docket a foreclosure action. The document that the servicer uses for this is called an order to docket. And I'm going through some of these in a little bit of detail because it's important for you as the homeowner to know what these documents are. And in this entire process, you would have received a lot of documents back and forth, but there's some that are quite important for you to take notice of. The first, as we've discussed, is the notice of intent to foreclose. And that can only be sent to you 45 days after a default has occurred. But the second is the order to docket. And that can only be sent to you, the homeowner, after 120 days after the default has occurred. Now, this order to docket will also include important information about your loan. But importantly, this order to docket will include either a preliminary loss mitigation affidavit or a final loss mitigation affidavit. What do these things mean? A loss mitigation affidavit is required by some of these rules, some of these newer rules that we've talked about. It's supposed to help the homeowner through the foreclosure process. What's happening with a loss mitigation affidavit is that the bank is swearing that they've gone through a process of reviewing your loan documents and reviewing your financial information. And they have made an attempt to find some loss mitigation option for you. Now, under the rules in Maryland, the order to docket that we talked about just now can come with either a preliminary or a final loss mitigation affidavit. A preliminary loss mitigation affidavit is the bank saying, well, we've done a preliminary review and we haven't quite finished yet, and we haven't quite made a determination as to whether or not there are loss mitigation options available for the homeowner. If the order to docket comes with a preliminary loss mitigation affidavit, then the bank must wait 28 days before, this is 28 days from the order to docket with that preliminary loss mitigation affidavit. It must wait 28 days before it can file what's called a final loss mitigation affidavit. The final loss mitigation affidavit is the bank swearing that they have reviewed your loan documents, reviewed your financial information, have reached out to you, and they have, for the reasons that they have to state within the final loss mitigation affidavit, they were not able to come to a resolution or find any loss mitigation option for you. Now, once this final loss mitigation affidavit has been filed, the homeowner, you, have 25 days from the receipt of this final loss mitigation affidavit to request foreclosure mediation. The request for foreclosure mediation is extremely important because this is the one opportunity that the homeowner has to, within the context of the foreclosure action in court, to request that there is a sit down between the homeowner and the homeowner's representatives and the bank and the bank's representatives. Now, we're going to talk in some more detail about foreclosure mediation in a later video. But for now, it's important to understand that the homeowner has 25 days from the filing of a final loss mitigation affidavit to request mediation. Now, if the homeowner chooses mediation, the lender, that request by itself delays the foreclosure timeline such that mediation has to occur before the bank can set a foreclosure sale date. If the homeowner does not choose mediation, The lender may schedule the sale of the home within 45 days of the order to docket. And that's if the order to docket has the final loss mitigation affidavit. If the order to docket comes with a preliminary loss mitigation affidavit, then the lender, the bank, has to wait 28 days from the preliminary to file a final loss mitigation affidavit. Once the lender, the bank, sets a sale date, you, the homeowner, have to receive notice of that sale date. And you have to receive specific types of notice having to do with the time, place, and manner of the sale. Generally speaking, this notice has to come to you, the homeowner, between 30 days before the sale and 10 days before the sale. There are also subsequent notices that you would have to receive after the sale. It's important to note that there might be some instances where the homeowner, even after a sale, can raise some issues with the court, asking for the court to set the sale aside. But these instances are relatively few and far between. Once ratification occurs, the new owner cannot simply just go in and kick the homeowner out. There's still a process that has to be followed. That new owner has to go to the court and request permission to receive possession of the property. Once that permission is received, then the new owner can then go and arrange with the sheriff as to going ahead with the eviction process. Now, I've said a lot today, and there are a lot of dates and times, etc. to think about. But it's important to note that the foreclosure process, as difficult and as stressful as it is governed by rules and timelines. And we've spoken about some specific parts of these timelines and some specific documents that you should pay attention to. It's important to work as quickly as you can with your bank, with the housing counselor, of which there are several and very good ones in this state. It's also important, if there are legal issues and legal questions, to work as quickly as possible with your legal service provider, whether it be through civil justice or your own private attorney. That wraps up this session of the foreclosure timeline in Maryland. Thank you for joining me, and hope to see you soon. Take care.